Afternoon. Welcome to our presentation for this afternoon on behalf of the Environmental and Energy Law Program. I'm Rob Glicksman, faculty member at GW, and it's my pleasure to introduce our speaker this afternoon, Victor Flatt, who is the holder of the Dwight Olds Chair in Law and the faculty director of the University of Houston Law Center's Environment, Energy, and Natural Resources Law Center. Professor Flatt graduated from Vanderbilt University with a BA in chemistry and mathematics and received his JD from the Northwestern University Law School. He clerked for both the Court of Appeals for the Sixth Circuit and the Washington State Court of Appeals. Professor Flatt has taught at Georgia State University College of Law and the University of North Carolina School of Law. He's also visited at various law schools, including GW Law this semester, where he's teaching administrative law and first-year leg reg course. His teaching and research interests extend to environmental law, torts, environmental governance in the private sector, the practice of environmental markets, and the regulation of the energy business. The recent scholarship includes articles on climate change and disaster relief, holding polluters accountable in times of climate and COVID risk, and climate change common law nuisance suits. He's been the recipient of numerous funded grants on environmental issues, on issues like climate change adaptation and Clean Water Act regulation. Professor Flatt has also maintained an active service agenda, including in his role as a member scholar of the Center for Progressive Reform, an NGO to which I also belong. He will speak to us today about the ethical challenges posed in connection with greenhouse gas emitters whose activities create risks of death or serious bodily harm. For those in attendance, if you have a question that you'd like to pose to Victor, please enter it in the chat and I'll keep the queue and return to it when Professor Flatt is done with his remarks. So Victor, take it away.
Thank you so much, Rob. And thank you for everybody here at GW for letting me come and visit and for doing this presentation. So I've entitled this presentation, Disclosing the Danger, Climate Change and Attorney Ethical Responsibilities. And if you saw in the announcement, I actually have already published an article on this, and that has even been republished in a couple of ways, shorter things, and that's been out about a year. And what I want to talk about today is not just the article and the ideas in that, but a little bit about how that has continued to play since then and what I think that is meaning for the future going forward. So let me start first by talking a little bit about the article. The main point is attorney ethics rules could be interpreted to require a disclosure of otherwise confidential information between an attorney and client. Why? Because greenhouse gases emissions can be considered deadly, and the spur to that will be climate activism, and attorneys should be aware of that. Let me give this disclaimer first off. I am not saying this is the best reading of ethical rules, and we'll get more into the details momentarily, but it is a possible reading. And for reasons that I'm going to talk about, because it is a possible reading, it is something that attorneys very much need to be aware of now and going forward. So the first thing that we should note is greenhouse gases kill people. They do. And there's no sugarcoating that. We don't think about it like that, but they do. They kill people as assuredly as guns do or knives do. And they may kill them in a different way, but they kill people. And I think it's very important to center us in that construct. The UN estimates that it kills, in 2012, estimated that it killed over 100,000 persons annually in direct causes. And you may recall that 2012, if you study this, was before we had fully developed the science of climate attribution. In 2018, as that science was beginning to develop more, the World Health Organization estimated if they could control various disease vectors, because that's how they were involved, that still 250,000 persons per year will die by climate change after the year 2030. And essentially that question continues to grow. According to the climate vulnerability index, also back to 2012, if you include indirect causes, these are that are likely attributable, but not directly attributable to climate change, the number increases to 400,000 persons a year. And the UN estimates that 5 million people per year are harmed by climate change. But as big as these numbers are, again, I think it's important to realize we are talking about real people who have real lives. This isn't or shouldn't be seen as just an abstraction. Similar, you hear this argument when people refer to numbers and things like genocide or the Holocaust or enslavement of people's right. Numbers are important. They show the scope and scale, but every single one of these is a real human being. And I think that concept is one that is starting to percolate through the legal sector, particularly among our younger colleagues and law students. And I'll come back to that momentarily. There's also been a litigation expansion in climate change. A lot of you follow this and know this. By 2018, local governments in these states, and now we've been in Maryland, of course, have brought tort lawsuits under their respective state laws against energy producers. There's public nuisance, strict liability, failure to warn, private nuisance, negligence, trespass claims. And there's, of course, been a big question about state common law versus federal common law that is not completely settled. But the climate activism bar, and I use that term neither as praise or pejoratively, is continuing and it is accelerating. So you can add to these tort things, cases now being brought in terms of consumer protection, cases being brought under fraudulent trade practices. All of these are attempts in various ways to utilize the legal system to control or limit how much greenhouse gases are emitted, to shrink that greenhouse gas footprint. The American Bar Association in 2018 resolved that all attorneys have an obligation to address climate change and to reduce greenhouse gases to net zero as soon as possible, and to use, they urge Congress also to use a broad range of legal mechanisms, et cetera. And they continue to say that it is a moral and ethical question, and that all attorneys should, in their best actions, attempt to limit the impact of climate change. So there's a climate activism bar, but this statement from the American Bar Association itself was quite controversial at the time. They are now looking to strengthen this, perhaps within this year, and we'll see what happens in that case. All right, so we've got climate change taking center stage and being of great concern in many different contexts. Now, that's all happening, right? Attorneys have their own pieces and places of this. And what is it that governs how attorneys relate to their clients? Well, it is the rules of professional conduct. And these have rules governing how attorneys are to act in context. Every state, all 50 states, the District of Columbia, and US territories have their own set of rules. However, many of these rules are similar. And they're similar partly because they both contribute to and draw from the ABA's own model rules of professional action, model rules of professional conduct. So I want to show you one of those model rules of professional conduct. This is the ABA Model Rule 1.6b1. It states that an attorney may disclose information if, one, it is to prevent reasonably certain death or substantial bodily harm. Two, in 2002, the requirement that it be related to a criminal act was dropped. So what we have now is simply this. The ABA Model Rule says an attorney may disclose information if it is to prevent reasonably certain death or substantial bodily harm. Now, of course, the states themselves have variations for this rule, and you can categorize them based on these sort of two axes. One is whether they're mandatory, must disclose, or permissible, may disclose, and also whether they're related to criminal or fraudulent acts or not. So among the states, 5 states require disclosure, require, not allow it or permit it, but require an attorney to disclose any confidential client information even if that information is not associated with any criminal or fraudulent activity, if it could lead to death or substantial bodily harm, and the disclosure would help prevent that. 7 states, including Texas, which is the largest state in terms of greenhouse gas emissions, require disclosures if there are criminal or fraudulent activities. 37 states permit disclosures. And those states are divided among those that permit disclosures if the client has engaged in a criminal or fraudulent activity, or some, about, I think, 13 of those, whether they've engaged in criminal or fraudulent activity or not. So we have a variation, but even if you look at the states that are permissible disclosure and include a requirement of criminal or fraudulent activity, it turns out that the impact of greenhouse gases may in fact require disclosures there as well. So one, you need to read this with other rules, other ethical rules. So an attorney cannot commit or further criminal or fraudulent acts that are already ongoing, and they must withdraw if the client will not cease those activities. And ABA 4.1b says, in the course of representing a client, a lawyer shall not knowingly fail to disclose a material fact when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client unless disclosure is prohibited by Rule 1.6. So I'm going to go back to that category of states. There are approximately 20 of them that permit disclosure if the client is engaged in criminal or fraudulent activity. Notice if you couple that with this rule, this means that because the Rule 1.6 would permit disclosure, it is not prohibited. If it's not prohibited, you then have to disclose under 4.1b if your failure to disclose would further the criminal activity or fraudulent act. And so when you read these together, it pushes the may disclose, in many cases, if it's associated with criminal or fraudulent activity, to must disclose. Well, what are some of the potential criminal or fraudulent situations that a client might be involved in? You might think, my clients aren't criminal. What if your client fails to report greenhouse gas emissions as required by the Clean Air Act? I'm going to come back to that. Or what about failing to report material financial impacts, et cetera? And what about the situation when you are representing a government agency? I mean, that's a whole big ethical issue itself, right? Who is your client, et cetera? And maybe their information may or may not be public, but you might need to disclose. And you might also need to withdraw if there are potential problems. All right, so these are potential situations. Now let's look at it in the context of actual state rules. I'll start with New Mexico. This is the New Mexico Rule of Professional Conduct 16-106b1. It actually is an exact duplication of the ABA's rule. You may reveal information if it is necessary to prevent reasonably certain death or substantial bodily harm. It's a permissible disclosure, but it does not require a criminal or fraudulent act. Texas, on the other hand, is not it is a mandatory disclosure. If the client, but only if the client is likely to submit a criminal or fraudulent act that is likely to result in death or substantial bodily harm. In that case, the lawyer shall reveal confidential information to the extent the revelation is reasonably necessary to prevent the client from committing the criminal or fraudulent act. Let's focus on a few key phrases in these state rules. What is a criminal or fraudulent act for purposes of the rules of professional conduct? What does the term likely to result mean in the rules of professional conduct? And what does it mean to prevent death or substantial bodily harm? Two of these are always necessary, right? You have to show that the information or that the activity is likely to result in death or substantial bodily harm, and that the disclosure, whether permissible or not, whether associated with criminal or fraudulent activity or not, is necessary to prevent death or substantial bodily harm. All right, so crime. The one I focus on first, and I talk about this in the article, is a failure to correctly inventory and report greenhouse gas emissions. As of 2016, studies had indicated that at least half of the largest emitters of greenhouse gas emissions, those over 25,000 tons a year that are required to report under EPA requirements under the Clean Air Act, did not do so. And you can imagine that these rules were not enforced any more strongly during the Trump administration. The Obama administration essentially did not enforce them, did not penalize people for failing to do that. But if you just look at the law itself, EPA requires entities of a certain size to report their emissions, and that requirement, that rule, is based on a promulgation pursuant to the Clean Air Act 111E performance standard. And sections 113.1 and 114 of the Clean Air Act criminalize any false or omitted statements required by a performance standard. So half of our largest emitters as of 2016 were engaged in criminal conduct, even if they were not being enforced or told to correct that criminal conduct. All right, so that's one example of a criminal issue. What about fraud? Well, there have been multiple allegations and investigations of financial reporting violations. There are questions about SEC violations, and I'll come back to that momentarily. You all remember Letitia James, the New York AG, who brought the fraud case that went to trial against ExxonMobil. She lost that case. And I think probably correctly based on the theory that was presented in that case. But there are also current cases going on in Massachusetts and in Minnesota. And with relation to the SEC violations, I will just note that the Securities and Exchange Commission requires companies to report yearly and in any public statements anything that could affect their financial bottom line or value of their shares. Many companies historically have not reported issues relating to climate change. That has changed. They are reporting more now. That is still in flux, however. And the Biden administration has indicated that it is going to strengthen those reporting requirements to be more specific with relation to climate change. What about the term likely to result in death or serious bodily harm? Well, I started this by saying greenhouse gases kill. But you might say to yourself, well, yes, they do. But is this one emitter, are their emissions really causing death or substantial bodily harm? After all, it's all of the emissions together. They're cumulative. We don't even know who might die or how they're going to die. If you go back to the paradigmatic case here, when the rule was first proposed in the 1980s, it was in response to tort cases from the 70s that indicated that professionals had a duty to disclose information to protect the lives of third parties. And that paradigmatic case would be something like your client comes to you and says, I'm going to kill the judge, or I'm going to kill this witness, or I'm going to kill my ex-wife. And in those cases, if you believe that's a credible threat, you must report it. And that suggests a certain kind of thing, right? If that's your traditional view of this part of the ethics rules, then you're going to say, well, this isn't like that at all, right? That's a specific person killing a specific person or threatening to at a specific time or within a particularly short period of time. Fair enough. But since that time, all that the ABA and the states have done is simply expand the breadth of this rule. So I will just point out, this does not have to be a specific person. It does not have to be at a specific time. It does not have to be in the United States. The comment to ABA's rules 1.6b1 states, such harm is reasonably to occur if it will be suffered imminently. Okay, that sounds like immediately. Or if there is a present and substantial threat that a person will suffer such harm at a later date if the lawyer fails to take an action that is necessary to eliminate the threat. And the example used for the ABA comment, and again adopted by states like New Mexico, is if your client spills something that is hazardous in the town's water supply, nobody may be drinking it now, the harm may be only due to future cancer, but you must disclose that even though the party is not identifiable, even though it's in the future, and even though it is not specifically certain. There merely has to be a present and substantial threat that the person will suffer such harm at a later date. And to me, that analogy rings very true in relation to greenhouse gas emissions. And that doesn't mean necessarily, doesn't deal with the issue of multiple causes of that, but I'll refer to that again momentarily. The last key term is prevent. All right. All I've been saying may be fine and good. Maybe you buy that this could cause death or substantial bodily harm, even if it's just a small piece of it. But how is it that reporting your client's, let's say, crime and not reporting their greenhouse gas emissions, how does that prevent death or substantial bodily harm, right? Haven't the emissions already gone into the atmosphere? How is that going to prevent anything from occurring? Well, there are several answers to that. One is that a failure to report, in this case under the Clean Air Act specifically, may be considered an ongoing violation. I say may be considered because there are, I believe, only 4 cases that have looked at it. 2 of them have indicated that it is an ongoing violation, meaning that if there has been emissions in the past that have never been reported, then you are still in violation. And if you're in violation, that means you must report to avoid criminal activity, and that suggests that stopping that violation is necessary to prevent the harm. That is, telling, if you will, telling on it is a continuing violation. I think more importantly is that reporting prior unknown greenhouse gas emissions will encourage fewer ongoing emissions, or in the case of issues with criminal violations or even civil violations, the relevant agency may require mitigation. So if you are an entity and you have emitted 25 million tons of CO2 and failed to report that, it may be possible that one of the penalties could be that you have to buy carbon credits to cancel out what you have done in the past. And so that it essentially would lead to fewer greenhouse gases in the atmosphere. And then there's just the theory of disclosure. The theory of disclosure, I think most seen in our current laws in the Emergency Planning and Community Right to Know Act, is that when entities must disclose bad things that they are doing, they're likely to do less of it. That's the whole basis, in fact, of the private climate disclosure project, which is a consortia of multiple private entities that agree among themselves to publicly disclose emissions, even when it's not required by law. And the purpose behind this is so that by doing this reporting, it will encourage them to see ways to reduce and give them an incentive to reduce. So in other words, the mere reporting of bad activity, like an unpermitted release of greenhouse gases, or an unreported release of greenhouse gases, or a release of greenhouse gases that affects the bottom line that is not reported in financial statements, all of this, the very reporting of it, would, everything else being equal, push the entity that did it to do it less. And if you're putting out less greenhouse gases, you are preventing some kind of harm. Well, how much kind of harm are you preventing, right? Is there a level of significance? If you're an attorney and your client drives to work one day, do you have to say, my client just emitted, X amount of greenhouse gases? Query whether that, let's say it's not associated with any crime or fraudulent thing and it's required at any time. Well, I guess you could argue that has some amount of danger, but where is the level of significance? Where does such a reporting requirement start? Well, one thing, it clearly must be human-made. It has to be beyond natural. Something has to be of a human intervention. And that is because greenhouse gases, in fact, are positive. Our natural greenhouse gas cycle is necessary to maintain life on Earth. It essentially raises the average temperature of the Earth about 52 degrees Fahrenheit. The question and the concern is the additional amount that humans are causing to occur at a rapidly increasing pace even just 1, 2, 3 degrees, 4 degrees, which cause a huge disruption because they're occurring over a smaller time period, and they're occurring with relation to a world that has physically evolved and then socially, culturally, and legally evolved around a more static environment. So these additional human things certainly would be necessary to qualify as a greenhouse gas emission that could cause death or substantial bodily harm. Now, that said, the UN has estimated that 132,500 tons of a greenhouse gas emission, that's a CO2 equivalent, would be responsible for 1 statistical death. All right, how do they do this? How can they do this? Well, interestingly, with greenhouse gas emissions, they do proceed in a linear fashion, right? The harm tends to be cumulative, and it is additional. In other words, even though we may have some kinds of harm that maybe occur at a particular level of amount of CO2 or CO2 equivalent in the atmosphere, maybe so-called irreversible things, we don't really know where that is. And every additional amount you add becomes a particular addition to the problem. This was recognized in the case of Massachusetts versus EPA, where in the court's standing analysis, it noted it didn't matter if the US new automobiles would only produce 2% of the emissions. 2% of the emissions, according to the court, cause 2% of the harm. If Massachusetts is going to lose, a meter of sea level rise, and one person produces 1% of that, well, that 1% is going to be responsible for 1 centimeter rise. So every bit contributes in some way, and this is how the UN comes up with this estimate. So let's compare that and explain. This explains why I focus, and I believe that this rule would typically focus only on large emitters. Let's look at a scale comparison. In 2007, the Share coal-fired power plant in Juliet, Georgia, emitted 25,300,000 tons of CO2 in 1 year, which according to the UN is enough for 190 deaths. In contrast, there's the Share plant. In contrast, the average automobile in the United States emits about 6 tons of CO2 every year, meaning that an individual car would have to operate for around 22,000 years to cause 1 statistical death. Well, what does all this mean, when you bring it together? What could the future really hold? I will just note that it is easy to bring complaints under the ethical rules. There are no standing requirements. You don't have to be a client. Anybody can bring them. This is how we have seen these weaponized in the service of political issues. Bill Clinton was removed from the Arkansas bar for lying in the Monica Lewinsky situation, but his complaint was brought by an unrelated third party that did not live in Arkansas. We've seen similar complaints brought against Rudy Giuliani, Sidney Powell, Kellyanne Conway, none of which are related to our traditional means of attorney misconduct like stealing funds or criminal things, but for just a violation of a rule. It's possible that in the future a comprehensive bill might preempt something like this if we actually had a comprehensive CO2 or greenhouse gas inventory, or I'm sorry, greenhouse gas specific bill in the United States. We don't have that now. The other thing that the future holds is that climate activism is continuing to grow, right? We now see that our law schools are protesting having firms on campus that represent large-scale greenhouse gas emitters, particularly in litigation. And they have put forward rankings of firms that indicate which firms are not doing a good job. The law firm Clifford Chance in London last month just announced that it was going to start doing climate conflict checks, meaning that just as any law firm does a conflict check with new business or activities of attorneys or partners to see that they're not causing a conflict with current clients, the Clifford Chance firm is going to start avoiding anything that comes with large greenhouse gas emission because they don't want to be associated with that. And sweeping discussions are now undergoing in the International Bar Foundation and the ABA about where this is likely to go. This paper, I think, touches one aspect of the role that attorneys play in the climate change context. And it's an aspect that you can focus on quite specifically, and as I said, may not be the best reading of the ethical rules, but is a reading of the ethical rules. But beyond that, more and more questions are coming up as to what the attorneys should be doing in these situations. If you're thinking about what could be an end game for this, why are people pushing this? Why are people thinking about it? There are multiple possibilities, right? The ideal, I think, is to hobble large greenhouse gas emitters by pulling away their ability to get good legal assistance. Attorneys are completely necessary for most of the business that goes on. And without attorneys or enough attorneys, the client may find it more difficult to do that business, thus bringing pressure on the client. It also can serve as a shield to whistleblowers in firms that are attorneys. It may make companies hesitant to undertake actions that they would have taken otherwise. It encourages attorneys to think about this as they give advice, even though they're supposed to represent their client's best interest. You cannot divorce yourself from what is occurring and what's happening in the world and your own feelings about it. So all of these things may be there, and there are other things that can come up as well. But I think this is an issue. The issues of disclosing or not disclosing are one facet of the attorney's increasingly complex relationship with clients who are emitting greenhouse gases. So I've talked too much. I'll stop there, and I will open it up to questions and discussion.
Thanks very much, Victor, for that illuminating talk on an issue that probably doesn't get as much attention as more traditional regulatory issues. Anyone have a question that they'd like to pose? If so, just raise your hand. Dick Pierce.
So I have about 50 reasons to be extremely skeptical if anything is ever going to happen of any significance in this context. But let me just start with a few queries. I mean, one, I think it makes a big difference. I can think of scores of contexts in which this issue might arise. And the context could matter a lot for a lot of reasons. First of all, in some contexts, it would not be the canons of ethics, but attorney-client privilege and the scope of attorney-client privilege that would be at issue. And while it's got lots of exceptions to it and qualifications, they're different than so you'd have to analyze it that way. And then another, of course, is the distinction that I think you implicitly recognize between a may and a must. That's the whole ball game. Any lawyer who says, well, I'm allowed to disclose all these client confidences, so I will, better announce his retirement the same day, because this is the last case he's ever going to get from anybody with any money. It's just, this would just absolutely infuriate anyone. It might be, even companies that have nothing to do with climate change or not causally related in any way are going to say, there but for the grace of God go I, and no way in hell will I ever trust this guy with anything. So let me turn this stupid thing off. But then I got some questions that relate to no matter what context it arises in. The relationship, the causal relationship to the risk of death to someone is minuscule. I mean, it really is. In Massachusetts versus EPA, and by the way, that would come out 5-4 the other way, or maybe 6-3 the other way today. But In that case, what they referred to is all emissions from all new cars. And they said, oh, it's not too trivial to, but when you start talking about, say, all the emissions attributable to Exxon's sales of fossil fuels, you're still talking about a relationship that is minuscule. If that is sufficient, then why haven't we seen this litigation in the context of small particulate matter, for instance? Just sticking with emissions. The causal relationship is much easier to establish. It's much more powerful since most of the deaths are within relatively close proximity or downwind of the emission source. It would be much easier to establish a relatively direct and pretty powerful causal relationship. And if you're going to go with statistics, why isn't every manufacturer of trucks responsible not because of their emissions, but because of traffic accidents? We know that statistically, if you put 10,000 trucks on the road, you're going to get X number of deaths. And you can make that argument about any number of things where the causal relationship is more direct and easier to establish than this one. So I just have great trouble imagining we will ever get to the world where the canons of ethics, when the Congress of the United States will not touch climate change. And they have proven that again and again and again. And I suspect forever they will continue to say, we will do nothing about this. I understand why people get desperate to try and find other means, but that also makes it even harder to get anything out of the courts, because I suspect that even outside the federal court context, they'll respond the way the Supreme Court did to the Connecticut case. We got agencies, responsible, politically accountable agencies and legislatures who are out there trying to address this. Why the hell should we take it on ourselves to address this? We are the least politically accountable institutions of government. In any of that, that's just kind of a starter on my list of 50 reservations.
No, thank you, Dick. I'm sure you're asking and posing actually questions that I'm sure a lot of other people are thinking. And I will try to go through them because I agree with you in many ways, but I want to address some of them that I think may make this more salient than it might seem at first glance. So the first thing, your first remark was, I don't see this ever happening in a million years. Fair enough. I will point out that it only has to happen in one state with one complaint. The complaint doesn't even have to be reasonable. What states do is they then contact the people that say they're under investigation. And again, that may not happen. Although I think given what you talk about with the activism and the desperation that people see, and the ease to bring an ethical complaint and no penalties for bringing an ethical complaint, and this wouldn't be a penalty because you could certainly say it covers it, that this could occur. But my bigger response is it doesn't have to happen to impact. The mere fear of it happening causes an impact. Our attorneys, as you know, we're a conservative bunch. We don't want to get into trouble. I mean, why is it? Why do you see attorneys turning away from certain kinds of representation, particularly young attorneys? Part of it's moral. I mean, just like we saw with the tobacco issues back in the 80s and 90s, but some of it is just not wanting to be associated or having a fear. A lot of your other questions, which I think are very good, are about the causal relationships. And that goes to your issue about trucks, right? The statistical deaths. It goes to the percent, how much. And I think you're right about Massachusetts versus EPA, but at this point in time, that reasoning is still good law. And what I will what I will point out is that I'm putting my torts hat on now. in a classic torts construct, this would meet the definition of causation. It would be percentage causation legally. It would be the example of one neighbor's 50 cows get into your field and another neighbor's 50 cows get into your field. It's not joint and several, but each person is responsible for their own 50 cows because those are equivalent units. Greenhouse gases are definitionally that way. They are chemical. They have a specific action. They are indistinguishable in their impact by the carbon dioxide equivalent. And so that is in certain ways a difference, for instance, with trucks, right? With a truck, a manufacturer of a truck, you can say one person is manufacturing safer trucks or doing this or that. Are the trucks going to have accidents? Yes, they may, but that may be a trade-off that is that we have permissibly decided we want to do. It's a benefit. You don't seem, you know, it's a risk that people also voluntarily undertake, right? The death from greenhouse gas emissions is not a risk that people voluntarily undertake. And that's been the basis a lot of these Deceptive Trade Practices Act and Consumer Fraud Acts. And I'm really glad you brought up the deaths from particulate matter, because I think that is so important and such a good illustration. And I hope I can explain why I think we're seeing a difference, or why we're not seeing something in that context. I'll just put it that way at the moment. So I will start by noting that also, you know, I made the analogy that this is kind of similar to hazardous waste, right? You can have multiple sources of hazardous waste. Hazardous waste can cause harms in the future. Why was this never brought up with hazardous waste? Why did we not see some kind of explosion of ethical complaints against attorneys who represented people who contributed to hazardous waste impacts? Well, that actually was written about in the 1990s. Irma Russell, in fact, wrote a really good article about that and noted how ethical violations could be read to apply to that. But the reason, in my opinion, that we didn't see any activity there is because we already had a comprehensive regulatory system that could deal with that problem, right? Rather than be concerned about whether or not your client has, you know, whether their discharge of materials, let me back up. Rather than be concerned about if an attorney failed to disclose the discharge of materials, what you would be concerned about is the cleanup of those materials and the regulatory requirements and the violations you would seek to impose on the person that did it. We have a comprehensive RCRA, we have CERCLA. That is, the law in essence takes care of that. And for particulate matter, we have the same thing. We have the Clean Air Act. We have a heavily regulated system that ostensibly, although I agree it's not true, ostensibly, by its very definition, protects the public health and welfare at the amount that is supposed to be allowed or permitted within each state. So I think that's the difference. That's why your point is exactly right, that people are desperate. They're more desperate. They're more willing to try different things. And that desperation has reached its greatest peak in the United States precisely because we do not have a comprehensive bill, and precisely because we're unlikely perhaps to get one in the near future. If you looked at the list of litigation that I talked about, if you look around the world, there are about 2,000 ongoing climate litigation liability schemes, primarily in torts, but in some other theories as well. 1,700 of those are in the United States. That's not a coincidence, right? Other countries have regulatory systems that are designed to deal with this. The other country, and by the way, Australia, the UK, Canada have identical ethical requirements because they were copied and they were based on the ABA requirements. And I think that this is something that is being looked at as in desperation by folks in Australia as well. In fact, I know that's occurring. So I think I agree with you in the sense it's not likely, it's not probable, it doesn't seem to make sense. Our courts would not like it, but people are desperate. It's very easy to do. The mere fact that it's easy to do puts fear in the hearts of some attorneys and creates a chilling effect. And it's not going to go to our courts, right? This is a state regulated issue. And yes, a state like Texas, I'm sure the state Supreme Court or the State Bar of Texas would pretty quickly get an amendment in to say, this does not apply to this situation. But I'm not sure California would. I'm not sure Oregon would. I'm not sure Vermont would. And remember how expansive attorney ethical issues are, right? Not only can you not commit a violation, you have to report someone else who commits a violation. And if you are disciplined in one state or even under investigation in one state, if you're barred in more than one state, that has to be reported to the other state. 25% of the attorneys in Houston are barred in more than one state. 12% of those are barred in California and Texas. And by the way, yes, there is a difference with the attorney-client privilege. I think I mentioned this in a footnote, or there's a discussion of it in the paper. Basically, it's been held more or less that even though they're technically different, that if it's the disclosure is allowed under the ethical rules, you generally would not be in violation of the attorney-client privilege. That's not always true, and I do address that there. In any event, thank you for your questions and thank you for engaging with this.
Other questions? Victor, I have one. So you, in connection with your discussion of the definition of prevention, you talked about mitigation and its connection to prevention. And the example you used was that if somebody failed to report greenhouse gas emissions, a remedy could be imposed that required the purchase of carbon offsets. Would that work as well in the context of a failure to report as it would, as it seems to me more clearly, in the context of activities that result in emissions in violation of regulatory caps? I think that the link to a mitigation remedy there is quite clear, but to me, it's not quite so clear in connection with a reporting violation.
I think that's absolutely right. Right, it is much clearer with a violation. And I will note that even though we don't have comprehensive US law about emissions limits, we do have emissions limits in some areas in some states. So California, for instance, we do have emission limits for electricity producing entities in the Northeast. And those limits would also apply if you were operating in another part of the world like the European Union or China or Japan. My analogy about failing to report was only, again, the link that would have to be made by the agency would be, you have, by failing to report, you are causing harm, and we are going to tie that to mitigating that harm. And I agree that's not as direct a potential. So I think you're correct about that.
Let me ask another question relating to reporting. So you mentioned the Emergency Planning Community Right to Know Act as sort of the paradigmatic example of a scheme that's meant to try and create incentives for people to reduce undesirable activity for fear of being outed as being a bad actor. And the numbers I've seen indicates that the statute has really worked quite well. And that since the adoption of the statute as an amendment to Superfund in 1987, there have been significant reductions in emissions of or management of certain hazardous substances. But at the beginning, you indicated that there's massive violation of greenhouse gas reporting requirements. Why the difference? Why haven't we seen the same kinds of responses to reporting obligations in connection with greenhouse gases that we've seen under the Right to Know Act, do you think?
Two reasons. It's newer, for one, and willful avoidance of the issue for another. And the fact that the Obama administration made a decision early on, and I think this was widely understood, that they were not going to try to penalize, they were going to do cooperative enforcement to try to get, help people learn this new program and let's get started with the reporting. And it was also part of course, their larger scheme of other greenhouse gas reduction plans like the Clean Power Plan, of which eventually came out, that were maybe legally more potentially problematic. So they just weren't anxious to do that. And in fact, they never did. I mean, they only now in the Biden administration, they are looking at that and indicating they're going to give penalties on it. But this is the weird thing about the distinction between attorney ethical rules and enforcement of existing laws, right? It doesn't matter if they're enforced or not. For purposes of the ethical requirements, a crime is a crime is a crime. It doesn't have to be enforced, doesn't have to be prosecuted, there doesn't have to be a conviction. It just has to fit under that rubric. And, you know, in that sense, it's sort of it's the attorney's role as facilitating that and facilitating obeying the law, even if the law is not being particularly enforced. So I don't have a really good answer, except that I think that the signals from the Obama administration originally were just that they were going to take it slow.
Alan Morrison.
So I guess I think it's pretty unlikely that any attorney on her or his own will, for the reasons that Dick gave an opening, undertake this voluntarily and provide information that's not public. I mean, I could provide all this public information and say attorneys have obligations, but it won't affect anybody. But my understanding of bar practices is that if I were to file a complaint about Dick Pierce for many of his transgressions, it doesn't automatically become public right away, although I could make it public. And the bar counsel then decides whether to move ahead with it or not. And the attorney isn't even notified until the bar counsel chooses to do so. And bar counsel can simply say, no reasoned decision required. And, you know, if I were bar counsel, my inclination would be to say, no. We just no. It's too many steps. Your logic is impeccable, but I'm not going to do it. I don't have to, and you can't make me. And so that's, you know, I'm not sure that I agree with all your reading of all the rules, but the combination is a pretty big step. And as somebody who's been used to pushing the envelope for many years, maybe it's just because it's not my idea that I think it's not likely to succeed. But I don't know. I think you're doing the profession a service by reminding them of their obligations, and there may be some cases. And of course, you can also remind them that if you don't think it violates the ethic, if you don't have an obligation to do it, you don't have an obligation to represent these people anyway. And you know, tobacco, that proved to be an important thing.
Right.
They become pariahs for that reason.
Right.
And you don't have to make it. I don't have to. You just say somebody else can do that. Or
So
go to another firm that doesn't do that.
Let me respond.
I like to tell my students they have that choice. Some students have more
Right.
choices than others.
Because we're just about out of time, I just want to respond to that question. It's a really good question, and you're exactly right. Almost every single state where you report, and I've looked at all the rules now, do have that sort of two-step process, right? It's usually filed online, doesn't have to be, usually it is. It's reviewed by an initial party to decide whether to go ahead or not. And usually that's the point at where the attorney would be contacted that this is an issue and that they're given a chance to respond. However, and I can't remember off the top of my head, there were a couple of states that, and it's probably, I think they're smaller states, that do give notice immediately to the attorney, just that anything has been filed. And they also keep sort of statistical records on that. I think that you're correct. I think in most cases that it's not public until the bar council has first ruled that it could proceed. But I'm not completely sure that's true in every single state. But getting to your point, which I think is really, really critical, yes, absolutely the bar council could say, no, I'm done. Well, I'm not doing that. But I think there's a possibility that one might say, oh, well, I guess we have to at least go to the next step. I mean, maybe, I don't know, maybe it's a little implausible, but maybe you're an activist, maybe that person's an activist, I don't know. I do think that is possible. And So I know my time's up, but let me just end by saying, I don't want to, I'm not proposing this as what should happen. I'm not. I'm proposing this as something attorneys should be aware of. I don't necessarily think that people who represent large greenhouse gas emitters are bad actors. Some of them, I think, are in the business to do good. I mean, I think they probably are having an effect in some cases to actually reduce their clients' emissions of greenhouse gases. I think that's very probable, and every attorney on their own moral decision will make that and make that determination. But again, we're talking about a weird ethical rule that has not been tested in this context and has really rarely been tested much at all, which is why I think we've had this spinning out of broad interpretations over time. So I want to thank you all for this opportunity. I really appreciate it. Thanks, Donna and Lynn and Rob and all of you for attending. And I'm happy to keep talking about these at any time when we have a chance. So thank you all very much. I appreciate it.
Well, thank you, Victor. I'm sure everyone agrees with me that this was interesting and provocative, and we're glad you were able to do this, and we'll see you all soon.
See you soon. Thank you. Bye-bye.